That courthouse, attorneys on both sides of this case offered up emotional closing arguments on Friday. Prosecutors wanted the jury to see Zimmerman as a wannabe cop who profiled Trayvon Martin as a criminal. The defense arguing that Zimmerman was guilty of only trying to protect his own life when he fatally shot Martin. Joining us now with some insights on the case, criminal defense attorney Keith Sullivan. He's joining us now from New York. Welcome. Great to have you here.
Good afternoon.
You know, those closing arguments were dramatic. Zimmerman's lawyer, Mark O'Mara, scolding prosecutors as having filled the jurors' heads with guesswork, not evidence. What impact do you think this is having in terms of the jurors' reaction?
Well, I thought Mark was very effective yesterday. I would have liked to have seen a little more drama, a little more emotion. George Zimmerman is on trial for his life, essentially, here, and I thought Mark could have come out with a little more fire at certain points and been a little bit shorter. But I can tell you what the jury is not doing. They're not doing what Mark asked them to do, which was go into the back and assess first the stand your ground law, the self-defense, and come back with 2 not guilties quickly. Had they done that, this, I think, would have been a quick verdict. We're into 6.5 hours now. They've asked for various forms of evidence that were submitted during the trial, so they're being responsible, they're taking their time, and they're going through it.
There was a moment when O'Mara brought out a slab of concrete to spotlight the fact that the defense wanted the jurors to understand that it was a weapon that Trayvon Martin used and that he was the aggressor, not Zimmerman. Here's part of that argument in court yesterday.
That is not an unarmed teenager with nothing but Skittles trying to get home. That was somebody who used the availability of dangerous items from his fist to the concrete to cause great bodily injury. Not that it's necessary for self-defense, but great bodily injury against George Zimmerman. And the suggestion by the state that that's not a weapon, that that can't hurt somebody, that that can't cause great bodily injury is disgusting.
How effective was that argument?
That was one of the more dramatic points from Mark O'Mara. It's interesting, he made reference to the fact that he resembles physically Joel Osteen, and I think his mannerisms and his charisma is sort of, you know, platformed as well as Joel Osteen alike. You know, he did something yesterday with that video that I thought was very effective, and the prosecution made a tactical error, in my opinion, in not allowing the video to be played during trial. Had they put it in as evidence during the trial, they could have attacked it, they could have impeached it. Instead, Mark was allowed to play it in summation without any comment, without any attacks, without any impeachment from the prosecution. I think that was a fatal flaw because the jury visually walks away with the version of the events as the defense wants you to see. Listening to the summations from the prosecution twice and the rebuttal twice, I'm still unsure as to what their theory is. There's too many gaps. They ran around that courtroom in the summation like rabid dogs, yelling, screaming, high octane, lots of energy, but none of it connected. And there's an old saying in trial law, if you have the evidence, you bang the evidence and you yell about the evidence. If you have the facts, you yell about the evidence. If you have nothing, you just yell. And that's what we saw from the prosecution. I really thought it was an abysmal job by the prosecution.
You know, in the state's rebuttal, though, the prosecutor John Guy asked jurors to use their common sense and said in his heart he felt that Zimmerman showed hatred and ill will towards Martin. In his description of Martin, he repeatedly referred to him as a child who had every right to defend himself from a stranger. Let's listen to John Guy for a moment in the courtroom.
Trayvon Martin may not have the defendant's blood on his hands, but George Zimmerman will forever have Trayvon Martin's blood on his, forever.
So he was very dramatic there. And then referring to Martin as a child, that was a departure in the way they portrayed Martin at the start of this trial, isn't it?
Absolutely. I mean, that was part of their theme through and through. Skittles, sugary iced tea drinks, young kid, just walking home. They can't explain where he was for those 4 minutes, that moment of silence, if you will, that Mark O'Mara demonstrated for the court where Trayvon could have left the area, could have left the scene, could have gone home and been secure in his house. I'm not faulting him by any means for not having done that. He was where he was lawfully entitled to be. But as emotional as that rebuttal was from the prosecution, it didn't connect the facts and the law. And the jury, God willing, is going to judge this case based upon the law and should come back with 2 not guilties to manslaughter and murder in the second degree.
Oh, we shall see what lies ahead. Keith Sullivan, thank you so much for joining us with your insights.
Thank you.
We're going to have